Hi, I'm Tom Marks with the Marks Law Firm, and I'm here back with my second video in our video series on YouTube, The Healthy Family Law Attorney. And remember, our passion is to provide hope and help to families in a healthy way to navigate the family law process. And again, that can include divorce, paternity, custody battles. But today I'm going to talk about a healthier way to approach family law, and that is collaborative family law. So collaborative process is newer to Florida. It's been around a longer time in other parts of the United States. But in Florida, the Florida Supreme Court and the legislature a couple years ago passed a statute and rules promulgating how we approach collaborative law in Florida. Now, I've been collaboratively trained and been practicing collaborative law for over 10 years. So it's been available, but it has not been as widely known or understood. And a new requirement is that all family law attorneys in Florida must give collaborative as an option to the family law clients. So what does that mean? Only a small percentage of family law attorneys are collaboratively trained, but yet they're all required to give collaborative law as an option. So let's talk about that. Collaborative process is a voluntary process where the clients come together, agree to sign a collaborative participation agreement, and to work outside the court system to avoid litigation, to avoid all of that expense. So you put together a collaborative team. Each spouse or party has a collaborative attorney. We're no longer thought of as opposing counsel. We're collaborative counsel. Then there's going to be two professional neutrals. One is going to be a financial neutral. They're going to put together equitable distribution worksheet, financial affidavits, child support guidelines, alimony analyzer worksheets, and so forth. And then there's going to be a mental health neutral. The mental health neutral is going to put together the parenting plan, is going to run the meetings, is going to help with any emotional, psychological issues, and be what's known as the facilitator. So it's a really powerful process by which family law clients can avoid litigation. So today I'm going to talk about the 5 reasons to choose collaborative law. Reason number 1, you avoid litigation. You avoid the court system, the courthouse. Even though we're in the pandemic and everything is virtual now, you're not going to have any hearings if you have a successful collaborative case. Of all the collaborative cases I've handled, I've only had one that was not successful. And so the vast majority end up being highly successful. So you avoid that litigation, you avoid that conflict, you avoid that hostility. And I find that most clients that end up having to go to court end up liking each other far less, or maybe in a negative way, but hate each other more. That's not good for the kids. It's not good for the family. It's not good for the extended family. It's not good for you and your health, emotionally, psychologically, spiritually, personally. So that's number 1. You avoid the court. Number 2, privacy. In the litigation process, when you file financial documents like the financial affidavit, which has on it your gross income, all your deductions, so your net income, all of your expenses, and it includes all of your assets and liabilities. So it has to be filed with the court because it's in a litigation process and you're in the court system. And you have that risk of people seeing what your income is, what your assets are, what your debts are. In the collaborative process, there's an agreement the parties reach not to file the financial affidavits. The financial affidavits are drafted and signed, but they're not filed. The collaborative financial neutral will take care of that, but the financial attorneys will hold on to those documents, and per the collaborative participation agreement, you don't have to file the financial affidavits. In fact, you don't even have to file the financial agreement, which is typically contained in the marital settlement agreement in the litigation process. This is a collaborative settlement agreement, and either you can file a shell that references what the real details are, so it keeps all of the financial and other matters of the divorce, paternity, whatever, private. Okay, so it's not seen by the public. Third, you avoid the outrageous cost of a litigation case. So if you do collaborative, you know you're not going to court if it's successful. And so you're never going to have the cost of having to hire all kinds of experts. You're not going to have a custody battle. You're not going to have a social investigation. You're not going to have a forensic CPA that has to ferret out all kinds of hidden assets in the case, which is very expensive. You can do a lot of that in the collaborative process, but it's not as expensive because the financial neutral, who may be a CPA, does that analysis, but the documents are all voluntarily produced. You don't have to do requests for production, interrogatories, mandatory disclosure, and so forth, and fight over that and have hearings to get documents that you need, which are voluntarily produced in the collaborative case. So a litigation case I have seen cost in the hundreds of thousands of dollars. I hate to say it, but not myself, but I've seen other cases in Central Florida cost in excess of $1 million on each side. Never had that myself. Hope I never do. But in a collaborative case, it's going to be far more limited. Typically, you have 3 to 4 or maybe 5 at the most meetings as a collaborative team, meaning the two parties, their collaborative attorneys, the financial neutral and the mental health neutral, and you get everything done. I have finished two collaborative cases after 2 full team meetings. So it's possible to do it not after, but at the second team meeting. Number 4, you reach your goals. What do you mean by that? Okay, in litigation, you may have goals, but it's not like the court really cares. The court wants to follow what the law is. The court is only going to hear on a day or 2, or if you have a really big case, 3 days, 5 days of testimony. He says, she says, this expert says, that expert says something different. And then the judge is going to have to make some kind of wisdom of Solomon kind of decision, cutting the baby in 2 or giving something here, something there, or making decisions based strictly on the law. Well, in a collaborative case, what you do in the very first meeting after you signed all the preliminary documents, the collaborative participation agreement, and so forth, you state your goals. So as a collaborative attorney, I prepare my client ahead of time. What are your goals? What do you think your spouse's goals are? Are they going to be in any realm similar? Are they going to be the same? Incredibly, so often, collaborative goals of one spouse and the other are very similar. They'll start out like this. I want to protect the children from the divorce, from the custody battle, from the litigation. I want to make sure that the children have enough to meet their financial needs. I want enough child support. It may be enough alimony. I want to stay in the marital home until the youngest child reaches the age of majority, typically 18, or graduates from high school. And then, it shifts over, and then let's say I'm representing the wife, and then the husband gets up and he says, well, my goals are to protect the children from the litigation process. I don't want them to hear about the divorce. I don't want them to be damaged from this. Yeah, I'd be happy that they could stay in the house until the youngest reaches 18. Yeah, I want to provide enough so that they have their needs met. And so all of a sudden, you have complementary, agreed upon kind of goals, and you're way ahead of the game. This is not a sense like even a mediation would be, where there's bargaining, position-based bargaining. I ask for more, hoping to have to pay less, and the other side's offering less, and it's all like a game. This is actually, you're putting your cards on the table. You're saying what your goals are, and you're trying to do it in a more amicable way, and it gets you to the finish line a lot quicker and with a lot less conflict. So number 5, I have preserve family relationships. You're really focusing on the future more and not on the past, and maybe not so much even on the present. You're saying, okay, I want to make sure that we continue to have a good co-parenting relationship. I want to make sure that the kids still love their mother and love their father. I want to make sure that they have enough, not just to get through childhood, but maybe start talking about, well, let's set up a prepaid college plan, or let's put together a 529 plan, or let's make sure they have enough to go to an in-state 4-year university, or maybe just a 2-year college. But you set those goals and you agree upon them and you set it up, and it's more future oriented. You're thinking about the big picture. You're thinking about the extended family and the relationships. I'm going to tell you that I've had cases where the collaborative process has gone so well. Husband and wife, although they're getting a divorce, they've worked out everything so well. They've reached meeting each other's goals in a collaborative way. They drive to the collaborative final, what we call a signing meeting, where all the documents are prepared. We make sure everybody understands and is clear and is in agreement, and then they sign the documents. But they sit next to each other, they sign the documents together, and sometimes they drive home together, and they are still amicable, maybe even friends. I've had collaborative clients, not even my client, but the other collaborative client, send me pictures of the kids at the holidays. I mean, that doesn't happen in a litigation case. I've had cases where my client, the collaborative client, has invited me to a barbecue, my wife and I, and said, oh, if I thought about it, I would have invited my former wife because she thought you were great and we're getting along so well. So that is the benefit. That's the healthier way of handling any family law matter, because your family does matter, and it preserves the relationships. That is kind of the nuts and bolts of a collaborative case. There's a lot more we could drill down on that, but I wanted to make sure this got out to you. If you like this or you found any value to it, let me know in the comment section. Hit that like button if you like. I'd love to have you subscribe to my channel. So thanks so much. Enjoyed it thoroughly. Hope to see you in the next video.